From Cypress, Texas, you've reached the Special Ed Section 504 Radio Hour. And I'm your host, Louis Geigerman. Once again, we're back, folks. Well, it certainly has been a hot and sultry summer here in Houston the last month, so I guess what's new about that? Fortunately, our hometown baseball team, the Houston Astros, is hot as the weather is, and they're on top of the American League West by, well, I think it's 2 games. I don't know if I think LA lost last night. So it's either 1 or 2 games they're ahead of the Angels. I went to an amazing game on Thursday night. It was a wonderful pitcher's duel. I know this may be boring. Some people don't like baseball, but this is, even if you don't like baseball, this was pretty good. The game was 0-0 until the bottom of the ninth. Both pitchers had pitched and pitching staffs had pitched like 3 hitters. It was just amazing. But the Astros got 2 men on base with 2 men out in the bottom of the 9th inning, and Jason Castro launched a high fly ball, went over a right center field wall for a 3-run walk-off home run to end the game. I am telling you, it's just as exciting as it can be. If you can't get excited about that, well, you'll never like baseball. By the way, if you haven't been out to an Astros game yet, do it, because you're missing out on perhaps something, a very, very special season. Hopefully, we're in the dog. We start the dog days of August and September. I don't know how much that applies to the Astros because they play indoors, but at least half of their games are outside the dome. Outside the Minute Maid Park. So hopefully the good guys will be there when we get into the playoff time. However, the reason why I wanted to talk about baseball today is that I have a really good friend, Jimmy Goldman, out in Sugar Land. And he's been involved with a baseball team for kids with special needs, and it's called the Dream League. And it's that allows kids that have difficulties and have challenges with almost any type of difference, for cognitive and physical differences, to play the game, just to play baseball. Now they have kids that are called angels that help the kids get around the bases and effectively play the game. My daughter, Kayla, was a volunteer with the team several years ago when she was in high school and absolutely loved it. But the reason why I'm bringing this up today is that the team has been asked, the Dream League has been asked to play an exhibition game prior to the international game in the Little League World Series in Williamsport, Pennsylvania. The format is they have the international team plays one game, the American final they play a game, and then they play the Little League World Series. Well, anyway, the team has raised over $100,000 to send the athletes, their families, and some of the angels with them to Williamsport. And what is really cool about it is the game maybe will be shown on ESPN. Now, originally it was, we're going to have the team on for that exhibition game on ESPN2. Now it's turned for it's different. Now they're saying maybe we'll have the game on. I think this crowd that listens to this station, I think what we need to do is turn the maybe into they will. And what I'm suggesting is I want our listeners across the country to contact ESPN and tell them you want the Dream League team that's to play the exhibition against the international team in Williamsport at the end of this month. Let's see, they're playing on, let's see what the day is. They're scheduled to play on August 29th at 11 a.m. Eastern Time. And I want you all to call ESPN, and by the way, the ESPN switchboard number, if you got a pen and paper, write it down. It's 888-549-3776. Let me read that to you again. It's 188-549-3776. Also, you can go to this webpage and you can write a comment or make a complaint, actually, to ESPN to ask them to televise it. And it's ESPN.go, as in go.com/ESPN/customer care/TV index. I'm going to do it again. Of course, this show is also archived, so you can go back and listen to the tape or listen to the podcast on the website later on if you don't get it. But it's ESPN.go, as in GO/ESPN/customer care/TV index. So this is truly a wonderful event, and hopefully these kids will be on. And I dare to say that there will be a lot of sharing of tears of joy to watch these kids play. And what's really beautiful about it is this is all about the love of the game. And the love of the game should be, everybody should share in that. Everybody should be able to share and play. I give some props to ESPN because they just televised the Special Olympics, and that's great. But we need to take it up a notch. This is the 25th anniversary of the passage of the Americans with Disabilities Act. We need to go out there and we need to show athletes enjoying what they're doing, no matter what stripe, no matter what difference they have. They should be showcased like anybody else. Heck, ESPN shows a lot of stuff that I don't know is as important as this is. They do the Lumberjack Championships. I think they can show this one-inning game with these deserving kids. So, again, call ESPN at 1-888-549-3776 or go to the website ESPN.go.com/ESPN/customer care/TV index. Now, some of you were expecting to hear Deborah McIlvaney on the show today. Well, unfortunately, Deborah became ill. And the problem is her voice was greatly affected, and really to the point where she really wouldn't be understandable on the radio. So I have a special guest today, Holly Griffith Terrell, that has graciously decided to come on and pinch hit for Debbie. Debbie, we wish you well. We want you to get well quick, and we'll have you on another show in the near future. I want to talk a little bit about Holly for a second. Holly is an attorney in Pearland, Texas, and her practice focuses on special education law, family law, and she does some contract law. I had a business contracts class when I was in college. I enjoyed that. A lot of people go, "Really? Ooh." But I'm glad you do that. Holly graduated from the South Texas College of Law here in Houston in 2005, cum laude, I might add, and worked at two highly regarded law firms regarding insurance litigating insurance cases, and oil and gas services company drafting and negotiating contracts. A lot of people, defending insurance company defense, while there's a lot of work, a lot of times people think that you sell your soul when you do that. And
you do.
Yeah, and you do, but it pays the rent. But there's a certain time when you want to, geez, I need to take a shower after that particular that particular case. Anyway, as well as oil and gas services company, drafting, negotiating contracts, but her passion and plan was always to start a law firm and practice family law. My God, we need that today. In 2012, Holly gave birth to a beautiful baby girl with Down syndrome and discovered a strong passion for helping families of children with special needs to navigate the complicated education system and receive services for their children that were promised under the law. In 2015, she started the law office of Holly Terrell and dedicated her practice in helping families with all types of family law issues as well as special education law. Holly's admitted to practice law in Texas and the U.S. federal courts for the Southern District of Texas. She enjoys music. Actually, we were kind of talking about music earlier at the studio. There's an incredible, Rick Calvert, the engineer and owner of the station, has an incredible collection of old LPs, and it's really something. Anyway, she enjoys music, reading, hiking, fly fishing. We've talked about that. I wish I could get a lesson, but she says she can't do that. And running and spending time with her daughters, Evelyn and Georgia. So, without any further ado, I want to welcome Holly to the Special Ed Section 504 Radio Hour.
Thank you so much, Louis. I am so excited to be here this morning. And thank you for that about the Dream League. I'm definitely going to give them a call or an email as soon as I get out of here.
Yeah, absolutely. And I hope that motivates everybody to do this, because I feel a little bit, well, my name's Louis Geigerman. I feel like Louis Black about this. If anybody's ever heard his humor, he says, I'm sick and tired of blank, and I'm sick and tired of this stuff in this case. But I hope this motivates people to go out there and do something about it.
Absolutely.
So anyway, let's talk about a couple of questions that I think would be on the minds of parents. One thing is, let's start with this question. When do I need an attorney in a special ed matter, or let alone even a 504 matter?
Well, the place I would start, I generally always recommend, if there's any kind of disagreement, you're feeling uncomfortable, you don't understand something, I always recommend retaining an advocate first. And at the very least, an advocate can tell you what's going on, help you work with the school, and they're very good at this, and they do this in a very non-adversarial way, and that might be all you need. At some point, if you've already retained an advocate, that advocate will know if you need an attorney. They will tell you. Now, if you're beyond that point, you haven't retained an advocate, you're at some kind of standstill and nothing is getting done, and your kid is being harmed in the process because, your kid is losing time in education, then yes, retain an attorney. And please remember that there is a 1-year statute of limitations in Texas, so you need to be cognizant of that so you don't let that run. Well,
let's talk about that for a second. Okay, when we talk about, and I certainly would agree, well, that would be self-serving if I said I agree that you should use advocates. I'm one. I think it's important because when you bring counsel in so early, that can really create an even more adversarial type environment. But let's talk a minute about the 1-year statute of limitations. Many of our listeners probably don't understand what a statute of limitation actually is and what that means.
Well, basically, pretty much all causes of action have a statute of limitations. Anytime someone wrongs you, they're negligent, they commit some kind of tort or contract violation, it's a way for people to find repose. You have a certain amount of time with which to sue them. Usually it's either 2 years or 4 years in Texas. Now, for some reason, Texas has decided that for these types of violations under special education laws, it's only going to be 1 year. for probably various reasons. So you have to be very careful. And that basically means that you have 1 year after the time of the alleged wrong, whatever happened that you're alleging is wrong, to bring a due process hearing against the school. 1 year is really not that long. It sounds a lot longer than it is, because during that time you're going to be trying to work things out, and that goes by very quickly. So I'm not a litigious person, although an attorney. I know that might sound odd, but I'm not one to run to the courtroom. But I would want to err on the side of being cautious so that you don't let that statute of limitations expire, and then you can't bring a due process hearing.
And that's a salient point. I would like to touch a bit, though, about the 2 and 4 year statute. In the last reauthorization of the Individuals with Disabilities Education Act, periodically, that's a special ed law for all our listeners, they reauthorize it, meaning they try to, quote, improve it, unquote, makes changes that improve it. And theoretically, they're supposed to do that every 7 years. They're late. they're not. It's way past when they were supposed to reauthorize it. It should have really been done in 2011. And we're already in 2015. So there have been conversations on the Hill, but Congress isn't working very well together right now. Not trying to be political, but that's just how it is. But in the last reauthorization in 2004, previously the IDEA had been silent regarding statute of limitations in special ed, and there was a lot of clamoring that they need to be more prescriptive for states to understand that, to be able to litigate or look back and to redress problems that have occurred in providing an appropriate public education. When the statute was originally crafted, the clear message is that they wanted there to be redress as soon as possible. Why? Kids are growing, and they're going to be a kid for a limited amount of time. So for litigation being protracted for years and years and years and years, it may be too late. So they wanted to have things on a lot shorter, be able to address the issues in a lot shorter time frame than you might in other types of civil litigation. So in the last reauthorization, they prescribed a 2-year statute of limitation, but they put the caveat in there unless the state had a shorter or a different, or unless the state had a different timeline that was shorter. And Texas took that. We almost, through the Texas legislature, I was involved in a bill to change it, but unfortunately it got killed because one of the parties left the state, and it killed all bills in the legislature. So anyway, they prescribed 2 years, but through the commissioner of education, the commissioners of the Texas Education Agency, they were able to get a law that basically said 1 year, which, as Holly says, is really, really a shorter period of time. You blink, and it's gone. Okay. And I might go one step further on that for a second. For those people kids that have an initial evaluation, there were some changes recently in the 2013 legislative session where if you're getting a child first assessed for eligibility for special ed, there were some specific time frames that used to be they would test. You send them a letter, they'll test, and they have to do it within 60 calendar days and then have a meeting in 30 calendar days after that. Well, it changed where effectively instead of calendar days it was changed to the language of 45 school days and then have a meeting 30 days thereafter. The problem is that if the evaluation occurs between 35 and 45 school days toward the end of the school year, then if it's between 35 and 45, then they have until June 30th to do the testing. School has until June 30th, and then have an IEP meeting within 15 calendar days, within 15 school days of the fall session, unless there was a need for extended school year. But if it was inside 35 days, the count would go and the count would continue when the new session starts in the fall. What I'm saying is it would effectively carve out the summer. So if you think about, if you made a referral, and let's say it was within 35 school days of the end of the year, then effectively you might not get an ARD meeting, or an IEP meeting, let's say in May. You may not actually get an IEP meeting until November. So there you have 6 months right there out of that 12-month statute of limitations to be able to redress any problems. So the time goes like that. So it's important to be on the stick. And what that 1-year statute of limitation means is it's looking back in the rearview mirror to redress any violations that the district has done. So I don't want to underemphasize it. That 1-year statute of limitation, it's like a meter. It's sands in the hourglass that are running. You always need to be mindful of the time to be able to file, and it's critical to be able to have that arrow in your quiver to be able to assert a child's rights.
Absolutely, it's heartbreking when you want to assert your child's rights and you simply just can't because there's no more time left.
Yeah. I want to take a second here. Can we just talk about a few of the steps about preparing for due process for a second? Let's talk about that. Let's say that there's something that you need to go to war on, and you need to file. What kind of things should a parent do to prepare for due process, do you think?
I think the first thing I always recommend is getting a copy of all your child's records, all of them. And you can contact an advocate or an attorney to help you get really good language to put in a letter to send to the school to make sure that you get every record they have. And I would always start there, or right after. Go ahead.
Yeah, I would chime in on that. If you all go to my email at our email address, I will send you a request to get the records, and effectively anything with your child's name on it, you're emailed to. Anything with your child's name on it, and that can be anywhere from emails and that's emails between staff that mention you or your child by name. A lot of times there's some very interesting emails that go back and forth. And if you go to SPED Radio 103.5 at gmail.com and say, hey, Lewis, I need a template to request those records, I'll be glad to send you that. So that's SPED Radio 103.5 at gmail.com, and I'll be more than happy to send that. But anyway, getting your records is important because you got to see what's been going on.
Absolutely. Yeah, you have to be able to see what's going on in order to get them evaluated as well, and that would be the next thing I would recommend is to get an IEE, which is an independent educational evaluation. And a lot of parents don't realize a couple of things about these. First of all, they are most definitely one of your best rights. You can't advocate on behalf of your child if you don't know what your child needs. And I'm an attorney. you're probably a parent. We need professionals to do these things. We need psychologists. We need educational diagnosticians to tell us, what our children need, what kind of services our children need, so that they can get a free, appropriate public education.
And it's really an issue where it's not about what I think or what you think a child needs. It really boils down to what expert opinion says what a child needs. But let's expand upon this, okay? The schools have the absolute responsibility to test the child for eligibility for special education. It's called in Texas, it's called a full individual evaluation. So, and they get the bite out of the apple first to do that evaluation. They must at least consider doing one every 3 years. And from that, they construct IEP goals and objectives. And that's what it's based on. It's sort of like you go to a doctor and you say to a doctor, I got a pain in my stomach. Well, what is the doctor going to say? The doctor's going to say, take 2 aspirin and call me in the morning? No. The doctor's going to say, look, I need to do some lab tests and then make a diagnosis. Well, that's effectively, it's data that drives the decision making. So it's important. So the school gets a right to do that in that FIE, but you have a right similarly to disagree with that that full individual evaluation and ask for a second opinion. And guess what? They have to pay for it. So why don't you expand on an IEE?
Oh, that's the coolest thing about the IEE is, yes, you make a request for the IEE, and the school has 2 options. They either pay for it, you get your IEE. That generally happens. Or they don't pay for it, and they must file a due process hearing if they decide not to pay for this IEE. And
in that case, and let's say they file for it, okay, there was what happens in that case? Ordinarily, and counsel, you correct me if I'm wrong, if you're the moving party in a lawsuit, who has the burden of proof? The moving party or the parties defending?
The moving party.
The moving party. So in this case, ordinarily, when a parent files for due process, they're the moving party. So they have the burden of proof. But when the district says they're going to defend their IEE, they become the moving party, and now the tables are turned. They have the burden of proof. And what does it mean to have to play defense?
It's a lot easier to play defense than to have the burden of proof. And considering this is basically a procedural violation, they usually get slapped on the wrist pretty quick.
Yeah, absolutely. So, in that case, let's say that the district takes the situation where they don't either say yes or they don't say yes or no, they don't do anything. What do we do then?
Then that's quite the quandary, and that does happen sometimes. You can file a complaint with the TEA, and it's usually taken care of rather quickly.
Right. It's a written complaint that you filed to the TEA, and usually you'll get fairly fast response on that. I typically don't recommend people do written complaints with TEA unless it's a very, very clear procedural issue. And when it's very, very clear that they have to do that, and the statute is abundantly clear that they have to do that, then having them weigh in can be very effective because they don't want to really be on TEA's radar.
Absolutely. And this is clear-cut procedural, and TEA will generally side with you on this one.
Yeah. Well, let's go a little deeper into IEE. So, why would you ask for an IEE? What are the advantages of doing an IEE?
Well, first of all, like we've mentioned a little bit, I'm an attorney. I'm not an expert, and generally parents aren't either. So in these types of things, so we need psychologists, we need doctors, we need people to really look at our children, test our children, and take a deep look and tell us, what kinds of services are really going to help our children educationally. That's what we need. Another really good reason to get an IEE is, what if you do have to go to due process? Well, what if you do? You need some evidence.
You need to have experts. I would tell people one thing when you're asking for an IEE, the schools will always ask you to please give a reason why you're asking for that IEE. You don't have to tell them. You do not have to tell them why you're asking for the IEE. You just say that you disagree. And frankly, I think it's really not a wise idea to tell them why you want the IEE. Why? You've just boxed in your argument for having the IEE, and that can potentially compromise a case if you take that to hearing later on. It's just better to say, I disagree, let's move on, and we ask for an IEE.
Absolutely. It's like you said earlier, you go to a doctor and you want a second opinion. You don't have to tell the doctor why you disagree with his opinion. You just want a second opinion. It's your body. This is your child. You're entitled to a second opinion.
And the process for asking for an IEE, ordinarily it's not an ARD committee decision, correct?
Correct.
Right. And so in that situation, the process is that you send an email or a letter. You got to do it in writing, and you send it to the director of special education for the district. And effectively, you say, my child was assessed for their FIE, and on X date, and we are in disagreement, and we request an IEE at public expense. That's essentially what you say, and put your name, and send it on. Now, at that point, what is the district going to do when you send them that letter? What is it? Let's assume that they say, yeah, we'll do it. What is their point? What do they do after that point?
After you actually go and receive the IEE?
No, when you send them that letter, okay, and they respond about the IEE, what is the district's response to that? Well, maybe you don't follow where I'm going. What I'm saying is they're going to send their criteria for providing their IEE, what credentials an individual has,
a list,
and the list. Let's talk. That's where I was going with it. What happens if they give you a list? Do you have to adhere to that list that the district gives you?
I would not recommend adhering to the list that the district gives you.
And my question is, so therefore you're not required to adhere to that list?
Absolutely not.
Right. And why wouldn't you adhere to that list?
These are people that the district has cherry-picked to perform these IEEs. You are the parent. I like to pick my own people to perform IEEs. I have people I like. Lewis has people he likes, people that will meet the requirements, the school's requirements, and I just don't think it's a great idea to pick directly from that list. Now, if there's someone you really like that's on the list, you are more than welcome to pick off the list. There's nothing wrong with it, but do not think that you are boxed into that list. That's not right.
Absolutely. I want to go one step further on that. With lists, let's say you pick somebody, or you, and I'm not. I want to tell you that I'm not. I'm not out to bash anybody or any organization, but you need to be careful about the people that you select for the evaluations. Like you said, with not necessarily adhering to the list. For one reason, you didn't say it, but one thing is that there may be a bias. Why? Because if you're on the list a lot of times, that means you're going to get a lot of business, and and they may be slanted toward the district, and you don't want that. But another reason is these are two issues that I think are key in IEEs, and Holly, you jump in if you disagree or you have a comment on it, and that is that you need to have evaluators that will see the child at school, particularly in psychoeducational evaluations or autism evaluations. There needs to be an observation at school. In fact, I personally would try to get people that could see the child no matter what the background is. A lot of times I find it difficult for speech paths to come in. They just simply seemingly always just do it in their clinic. But you want OTs, you need OTs, psychologists. You want them to see the child in class. I can't tell you the number of cases that I've been involved with where parents have gone out and have acquired assessments, IEEs, or, whether publicly or privately paid. And you can pay for a private IEE that you pay for, and the criteria has to be the same as what the school used when they did their own evaluation. But the issue is, I can't tell you how many cases parents have come to me where they've had them done through medical, through universities, from medical colleges. A lot of times the medical colleges will not let their evaluators go outside of their clinic and go out to the schools. And invariably, time after time, I see opposing counsel, well, not opposing counsel, when it goes to hearing, yeah, but when even in an IEP meeting, I see the school say, well, that's well and good that Dr. So-and-so saw this in their clinic, but we didn't see that, in the classroom. So a lot of times I see them bring in IEs that are disregarded for that very reason. You have to have an observation component as part of it.
Absolutely. I have a 4-year-old typically developing daughter, and she acts different from scenario to scenario, from scene to scene. So most definitely it would be important to have the IEE performed in the child's school setting, especially for the OT and the PT. They need to see what the surroundings are. They need to see where the desks are, and how the school's set up. It's very, very important.
And right. And, there's part of the, like in a PT scenario, an OT scenario, what their actual school function is. They have to look at what the school function is. So it's imperative that you have an assessment that includes an observation at school. It's absolutely essential, as opposed to just being in the clinic. But there's one other thing that I find, too, while it's important where you have the observation at school, the other part of it is, will that evaluator testify if you get in a dispute? And I find, a lot of times I find evaluators head for the hills like, oh, I don't want to be in litigation. I'm telling you now, if you have an evaluator that, A, will not do an observation at school, B, will not testify, you need to find somebody else.
Oh, absolutely. It's not particularly helpful if you're in a due process hearing and your evaluator will not come testify and back up their reports. You definitely need that.
You cannot, and as I said before, and you correct me if I'm wrong, really, these cases are really turn on. Decisions are turned on by hearing officers. They're lawyers themselves that are hired by the state to look at the evidence. These cases are all the time really turn on the validity of the expert testimony. And if you don't have any experts to testify, you're basically tying your hands behind your back and going into hearing, and you're going to get creamed.
Most definitely. And I would also caution, if there's an expert that just will not testify, there might be a reason they don't want to testify. They might be great at writing their reports, but you really want someone that can testify, answer questions on the spot, and do it in a convincing manner. That is, I cannot stress how important that is.
Oh, that's so true. I mean, how many people have we seen that write great reports but are lousy witnesses?
Yeah, absolutely.
And then there are other ones that write so-so reports and they're great witnesses. It's great to have both, but you really need to understand where they are and where they're coming from. But they need to be, and you want people that are decisive. You really don't want wishy-washy type evaluators. Well, instead of something like, well, that may be true, and that can be easily twisted on an idea. you want them always to use their professional opinion on something, but you want people that have clear ideas, that have clear thoughts on when they make a decision, when they make a determination in a report, they need to stick to it. And they need to be clear in their language. Wouldn't you agree with that?
Absolutely. These due process hearings do not happen in a vacuum. Hearing officers are human. You need someone personable, someone that's going to make a really, really good witness for you, someone confident that can stick to their opinion and back it up and stand up on cross-examination by the opposing attorney. And, some people aren't up for that. And if they're not, I would caution you to consider using a different evaluator.
It's interesting. There was a Supreme Court case, Schaefer versus West. And in that case, it really talked about the idea. There was a parent brought the case on the idea that the districts have all the firepower and all the documentation. They have access to the student all the time, and they have all the documentation. They have all the records regarding the student. And because it was, quote, an unfair advantage, for them to have that, have the student all the time and have the information, the burden of proof should be changed from the parent to the school district. And the Supreme Court said no. Supreme Court said no, I think it was 9-0, that no, there are ways. The reason is that you have the procedural safeguards which guarantee you rights to effectively level the playing field. And one of the things they said in Schaefer versus West, in the majority opinion, I think that was Senator Day O'Connor who said that, effectively, the IEE gives you the firepower to deal with the other side, the effective firepower to meet with, the strength of the other side, and that is to be able to have experts to see your child at school, and that is critical. But that can go one step further. There was a talk at a convention I was at a while back. Like, what does that mean? Well, shoot, your people should also be able to sit in IEP meetings just like their evaluators. And your people should be able to testify, just like their evaluators, to be able to level the playing field. So I think it's really, really a salient point of how important the IAE is. I still want to, I hadn't intended this to be all about IAEs, but this is such an important right that I think is really, really underutilized. And this is an important right for y'all to take. One of the things I found that districts are doing is they're playing the card on the criteria where they're turning down IEs because, quote, they're too expensive. Do you have any the fee that the evaluator is charging is too expensive? I have some thoughts about that, but I wondered if you had some thoughts about that.
I'm not aware of any caps on the fees. Are you, Lewis?
No, there's not. Okay, but what they do is there isn't a cap. But a lot of times what districts I find doing is they say, it'll be 20% over the Medicaid rate. Well, excuse me, there aren't any Medicaid evaluators that will do this type of assessment, and they use that to reduce the amount of money that they would pay.
Yeah, I would say that a letter in that regard is basically to put this nicely, get rid of parents that won't argue with it.
Well, they are. Okay, they do, and they'll fight that tooth and nail. But here's the thing to do, okay? They're allowed to provide their criteria, okay? One of the things that was talked about at this convention, which I thought was great, said, okay, they're putting some kind of fee cap. Then what you should do is you should go out and you should do an open records request, okay, and ask for all their contracting that they have done for evaluators for IEEs, and also for their own full individual evaluations for any outside evaluators that they personally hired. And get a hold of their contracts. I'd say do it for the last 5 years. Because if they're paying their outside evaluators more than they're paying for your people, then they got a problem, and they're going to be, and that's something to nail them in a hearing if that's what they, what's going to happen. A lot of times we find a way to do things too, and this is only in situations where people have the wherewithal to pay for them, is to simply, if they're fighting you in the amount of money and fighting you on the evaluator, pay for it yourself, giving the district notice that you're going to seek reimbursement, and then take that to a hearing officer and say, look, we had to use this individual, this is why. And, a lot of times the hearing officer should side with you on that, I would believe.
I would always get if you have to pay for it, pay for it. Because you need the IEE, most definitely.
Well, I've seen some things that one district, well, actually a couple of districts are doing. I'm not mentioning the district's name. But they said, well, this is a private pay IEE. You can't see the child at school. Actually have tried to say that. And I'm saying, like, let's take that to hearing. Let's tee it up, because they're very clear that has no bearing. They should have the same criteria that they had for their own evaluators, whether it's public or private. Criteria means they have to do things the same way they did it with the school did it.
Absolutely. Your child should be seen in the school setting regardless.
Another problem that I've seen is credentials. Okay, credentials of individual. If they said an LSSP did it, you have to have an LSSP do it. A lot of times that's difficult. So, the issue is if you have an evaluator who has the same or higher credential, there's a question whether you should be able to use that person as your evaluator. I would think yes, and I think I would take that to a hearing officer to determine. If they say no, it's got to be a lower master's level versus a doctoral level.
Oh, absolutely. If your evaluator has more credentials, that shouldn't be a problem at all.
Well, I've seen districts fight that a lot now. IEE, I have found that the IEE is the new, is really a place where they're really fighting tooth and nail. So y'all need to be ready for that. And I think the message for this is that, A, don't swallow their names from the off the bat. I would look to the advocates in your area who know the lay of the land, who know the evaluators. Ask them. I would tend to go not necessarily ask other parents, because other parents are usually going to be familiar with doctors, okay, and they're, medical doctors or psychologists in the private sector. If they're not doing IEEs, and again, advocates will know, the right people to use that have testified. They've seen the type of evaluations that they've done. I would look to the evaluators for recommendation. I would tend to stay away from asking parents on that, because I think they don't necessarily have the knowledge that the advocates do.
The advocates will know, and they will get you the entire package, the people who can write the report and testify if that becomes necessary at a due process hearing, which that's always where you have to look. Hopefully it doesn't happen, but get ready for it just in case. Okay,
I think I've pretty much we've pretty much dissected the IEE question, and I hope this gave you all some good information. It is, and it's the backbone of getting an appropriate education. Remember, the opinions by the IEE providers can provide you expert opinion for your hearings, and that's important. Let's talk a minute about least restrictive environment for a minute. What does that mean, and what should parents know in advocating for that for their children in special education?
Basically, least restrictive environment means that they need to educate your disabled child alongside other children without disabilities to the extent appropriate. And there are no least restrictive environment classrooms. I don't know if you guys remember, but when I was younger, things were different. There was a special needs room. I didn't interact with the special needs children, and it breaks my heart today since I have a beautiful daughter with Down syndrome. But that's not the way it's supposed to be now. They're supposed to be educated right alongside their typically developing peers to the extent that is appropriate. And there are some accommodations that will be made, and some that need to be made, because I want my daughter to get an appropriate education.
Well, I think one of the things that people have to understand, special education is a service and not a place. Let's take a continuum. What is the most restrictive environment? That would be the home. the child would be at home. That is the most restrictive environment. The idea is for kids to interact with their non-disabled peers, right? So it's the assumption that's where a child should be. But, on the other side, the least restrictive, and the least restrictive could be different from different kids, but, would be, the assumption is a child's in a mainstream classroom, okay, with providing, as you said, supplemental aids and related services. But when is a situation when it makes sense, or when should a child be considered to be in a more restrictive environment? Under what circumstances?
If it's appropriate and the child is not able to be educated in the least restrictive environment in that mainstream classroom, I think there would be different reasons, and this should be a decision made by the ARD committee, of which you, the parent, are a member. It's not.
By the way, we use ARD committee here in Texas, but for the benefit of the rest of you in the country, ARD committee is admission review and dismissal. It's an IEP team. Okay.
So, in my opinion, it takes a lot for you to not be educated in a mainstream classroom, as long as the school can provide the services and supplements necessary to make that happen, which is where we run into problems, because sometimes the school does not want to provide those services and supplements, to make that happen. It's a little easier to put all the kids in a special needs classroom and educate them separately. And I, as a parent, don't necessarily want my child in a special needs classroom all day long.
Right, and the problem with that is that the idea is that kids are supposed to be educated or have access to the general curriculum to the maximum extent appropriate. The general curriculum. But let's say a child is behind. Let's say the child's behind several years the rest of their peers. I mean, one way to deal with that is you drill down. Well, for instance, in Texas, our curriculum is known as the Texas Essential Skills, the TEKS. And those essential skills and knowledge, you can drill down on those TEKS to the level where that individual is. Okay, so you could find a TEK where they're operating at a very primitive level, but still you can teach that in a regular classroom. And the reason why you want to bring them in the regular classroom is that many of these kids in the mainstream classroom are going to be the potential employers of the child with a disability, and you want to expose those non-disabled peers to that kid because they're going to be the ones hiring them.
Oh, absolutely. I think it's just as important for the non-disabled children to be around the disabled children than the opposite. Right now, my children go to a private school where they are educated alongside non-disabled peers, and it's wonderful. My typically developing daughter goes as well, and inclusion is absolutely beautiful and really good for, like I said, the typically developing children and the children with disabilities.
Is that like a Montessori program?
It's called the RISE School.
Well, it's a wonderful school.
Yeah,
wonderful school. So the idea is that it's we want the child to be able to be educated in the least restrictive environment, maximum extent appropriate. So if it means a behavior plan, or if a child has a behavior problem, let's try a behavior plan. Let's try speech or occupational therapy to keep the kid in there. They don't have to be totally exhaustive of all the things they do to keep a child in a mainstream classroom, but they have to at least try and document that they try. Too often the default is, we can't do it, we're not going to do it. And also conclude putting in an instructional aid to help the student and give in-class support to a student with a paraprofessional. But what we need to be away from, there has been some decisions in the Fifth Circuit, we have to get away from the idea of creating a classroom in a classroom. So if we have an aide that's sitting next to that child all day, the class is getting one instruction, and the individual with a difference is getting different instruction. That's creating a classroom within a classroom. And the Fifth Circuit here in Texas has determined that that's not okay. That's not always
not inclusion.
It's not inclusion, and that's what we want to get away from. We want them to give them the ability to be able to be educated with their other peers.
Absolutely. That's life. They're not going to be in a special needs classroom forever. They're going to be out living life among typically developing peers.
Okay. I want to switch gears for a moment, and this will be the last issue we're going to talk about, and we're going to touch on that We want to talk for a second about prior written notice. What does that mean, and how do we use that?
Well, basically, anytime the school wants to change anything, they are supposed to give the parents prior written notice. And by change anything, specifically identification, evaluation, or the placement of the child. They want to change the identification of the child from a child with a disability and put him or her on a 504 plan, or change their environment. Anything they change, they need to give you prior written notice. And this is a procedural thing, kind of like the school having to pay for the IEE. It's very procedural.
And why is that important to be sure that you get their notice? A lot of times the schools call it their notice of refusal, but why is that important to get that documentation?
Well, it's important, especially the refusal, because that might start your statute of limitations. And like I know we harped on this a lot earlier. We've got that 1-year statute of limitations. You, as the parent, propose some services for your child. The school needs to give you prior written notice that they are refusing to give you those services, and that would be a really good way to say, this is where my statute of limitations starts. This is how I need to figure out when I need to hire an attorney to file a due process hearing, and this is how much time I have to do that.
So in effect, what the prior written notice can do is effectively box their position that we would form the due process case around.
I would go a step further. To get this documentation so that you have the start for your statute of limitations. If you do propose a change and they refuse verbally and they don't give you prior written notice, document it. Send them a letter.
In fact, anytime, would you agree with this? Anytime you want something, get away from, and this includes being in IEP meetings or anything. Anytime that you want to request something from the district, reduce that to writing. You need to ask them for it, and if they decline, well, then there's a problem. They need to do that. But documenting is key, because depending on what they say is something that could end up being as part of evidence in a due process hearing.
Absolutely. Document everything. I'm not a big fan of the phone, but if you want to call them and you have a conversation, document the conversation right afterwards. I'm pretty particular, so I send everything certified mail return receipt requested. You don't have to be that particular, but if you would like to be, it's very helpful. Make sure the date's on there and keep copies.
And so when you document it on the phone, say, thanks for my conversation of that date, this is what I understood you to say. If I don't hear from you within 5 business days, I'll assume that's what was said.
Absolutely. Document the time of the conversation, date, and who you spoke with.
Okay. Well, we're toward the end of the show today. First of all, I want to thank Holly Terrell for coming in. Holly Terrell has a law practice, and it's what's that? Terrell? LawOffice.com, is that correct?
Law Office of Holly Terrell.
LawOfficeofHollyTerrell.com, so check that out on the internet.
I'm sorry, I thought you were, the website is TerrellLawOffice.com. You were right for a second.
At TerrellLawOffice.com, it's TERRELL, LawOffice.com, and you can get this, this will also be, the recording will be on the website. Next week we'll have Lynn Akins, and we'll be talking about transition. And so I guess that's it for this week. So if you have any questions about transition, anything at all about transition, please send it to me at spedradio103.5@gmail.com. I'll see you guys next week. Thanks for listening, and I'll look for you on the radio and on the internet.
Hey, wouldn't you